Hi everyone, this is part 2 of the analysis of the government's fact sheets, which have been provided in conjunction with the new Employment Rights Bill. These are 10 fact sheets on different areas of the proposed legislation, and we hope to get some clues from the content of these fact sheets in terms of what might be around the corner and what might be consulted on. We've talked about the general one, we've talked about the unfair dismissal protection being abolished, and the unfair dismissal qualifying rights being abolished, and the 0 hours protection coming in. We're now going to move on to trade unions, and many businesses might say, well, this doesn't apply to me, I'm only an SME. It may well apply to you going forwards, because the fact sheet runs to some 13 pages, and this is a real flagship proposal that the government has made to placate the unions who have supported them during the election. Most importantly, the government is proposing to introduce a right of trade unions to access workplaces. Very concerning. There is no independent right at the moment, and functions have to be exercised through individual members in the workplace. The proposal is to create a framework which will create access agreements between the employer and trade unions, according to the fact sheet, for purposes such as to represent, recruit or organise members and to facilitate collective bargaining. Worst case scenario, the unions will be allowed into workplaces to canvass members, to try and sign them up, to promote the benefits of the union, and this could really have an impact on many more businesses than those who are currently represented internally. If the parties can't agree on a mechanism for such access, the infamous Central Arbitration Committee, which governs much of trade union law at present, will specify the terms on which that access should occur. Importantly as well, the trade union recognition process will be simplified. So there are certain thresholds which have to be met in order for an application to proceed. But in the future, unions would only need a simple majority of those voting to win, rather than 40% of the entire workforce. The union will no longer have to demonstrate they are likely to win a recognition ballot, only that they have 10% membership of the proposed bargaining unit, and this could, in future regulations, be reduced to just 2%. So I do think there is a risk of many businesses being unionised, or certainly a proposal to do so in the future, and the legislation is making it easier for recognition to happen. We'll move on to the fire and rehire provisions, and this contains some of the most inflammatory anti-employer language in my view. It says the government wants to end unscrupulous fire and rehire tactics that leave working people at the mercy of bullying threats. It also says that when the changes come in, good employers will also know that they will not be undercut by competitors who only engage staff under the threat of the sack. I think that's incredibly disrespectful language to use towards employers, but there we are, and I think that aggression says to me that this is one of the proposals they're really wanting to introduce, and probably one that the unions have put pressure on them to do so. That I've nothing more to say on that, aside from what's contained in previous videos, that there is a proposal to prevent employers and create a right to automatic unfair dismissal with no qualifying service requirement, where an employer terminates employment on the grounds of a refusal to accept a variation, except in very limited circumstances of financial distress. Finally, I want to pick up on the Fair Work Agency, which hasn't got too much attention in the media. So that there are some agencies at present who can enforce workers' rights on their behalf, and this is particularly in relation to national minimum wage protection and agency worker rights. So the Fair Work Agency initially brings those functions together, and according to the fact sheet, over time will take on enforcement of a wider range of employment rights. So it's already going to be proposed that the Fair Work Agency picks up the existing functions on minimum wage and agency. It will also include enforcement of holiday pay and statutory sick pay rights. And the fact sheet says that the bill will include a power for the Secretary of State to make affirmative regulations to expand the remit of state enforcement functions to include other employment legislation. That says to me that this could open the door for the Fair Work Agency to take on more work that an employment tribunal would otherwise pick up, and could ease pressure on that system as well. Time will tell on that front. The greatest risk, I think, with the proposals in general is a worry that this will just completely overrun the tribunal system. So perhaps bringing in something like a separate agency for contractual and statutory rights, such as holiday pay and sick pay, might ease that burden. We're going to continue publishing videos as we get into the consultation on various proposals. If you do need anything in the meantime, please do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.